Organized Labor and Negro Workers by Herbert R. Northrup. Journal of Political Economy, Volume 51, Number 3, June 1943, pages 206 to 221, published by the University of Chicago Press. Organized Labor and Negro Workers by Herbert R. Northrup. Footnote: anyone familiar with the penetrating analysis of this subject by S.D. Sparrow and A.L. Harris, The Black Worker, New York 1931, pages 53 to 115, will realize my debt to them. In addition, I have benefited from an unpublished manuscript by Dr. P.H. Norgren and from suggestions by Professor S.H. Slichter and Drs. J.T. Dunlop and J. Schuster. End of footnote. The racial policies. Footnote: the term racial policies, as used here, refers to policies directed at the Negro race. No attempt has been made to investigate policies toward the other colored races. However, the evidence at hand indicates that unions generally treat Orientals, Indians, and often Mexicans in the same manner as they treat Negroes. On the other hand, the AF Journeyman Barbers Union, which admits Negroes, excludes Orientals. End of footnote. The racial policies of American trade unions vary from outright exclusion of Negroes by some organization to full acceptance of them with all privileges of membership by others. Moreover, union policies toward Negroes are somewhat fluid and subject to change if the circumstances so warrant. For example, the appearance of a rival union with a liberal racial policy may result in a reversal of the policies of its competitor, which had up to that time discriminated against colored workers. The presence of an exclusionist union in the same jurisdiction with one which usually tolerates no discrimination may cause the latter organization to relax its principles for fear that it might alienate its predominantly white membership. The attitude of unions toward Negroes also often varies within the same organization from region to region, depending upon local customs and the type of leadership which is selected. It sometimes happens that Negroes are refused membership in an organization in one part of the country, while received freely by it in another. In one local union, a sympathetic president or business agent may play an important role in cementing good feeling between the white and colored workers. In a neighboring local of the same national union, a prejudiced leader may cause the whites to exclude the Negroes. Dynamic elements such as these prevent any clear-cut categorizing of American labor unions according to their racial policies. This fact should be borne in mind for the discussion which follows, in which 1. Union racial policies will be classified and analyzed, 2. The position of the American Federation of Labor, and 3. That of the Congress of Industrial Organizations will be set forth, and 4. An examination will be made of what the spread of union organization can mean to colored workers, using as illustrations the aircraft industry and the International Association of Machinists and the United Automobile Workers, the unions which have jurisdiction in that industry. Section 1. At least. Footnote: at least is said advisedly. During the last few years, many independent, quasi-independent, and company unions have been formed, mostly local in jurisdiction. No effort has been made in this article to examine the racial policies of these organizations. End of footnote. At least 15 American trade unions specifically exclude Negroes from membership by explicit provisions in either their constitutions or rituals. Of these 6, the airline pilots, the masters, mates and pilots, and the wire weavers. Footnote: The Wire Weavers Association admits to membership only quote unquote white Christian males and subjects aliens to an admission fee of $1,000. To the writer's knowledge, it is the only union in America which excludes non-Christians. Having a membership of less than 500, its influence is negligible. End of footnote. The Wire Weavers, all AF of L affiliates, and the train dispatchers, the Railroad Yardmasters of America and the Railroad Yardmasters of North America, which are unaffiliated, are of no great importance in barring Negroes from jobs, since none of them has a membership exceeding 3,000. Quite different, however, is the effect of the remaining 9 exclusionist unions, for they include some of the larger and more influential organizations in the American labor movement, namely the International Association of Machinists, the Commercial Telegraphers, the Railroad Telegraphers, the Railway Mail Association, the Switchmen, the Locomotive Engineers, the Locomotive Firemen and Enginemen, the Railroad Trainmen, and the Railway Conductors. The first 5 of these larger exclusionist unions are AF of L affiliates. The last 4 are independent. Footnote. The last 4 are the quote-unquote Big 4 railroad operating brotherhoods. During the last few years, 2 small exclusionist unions, the Independent Dining Car Conductors and the AF of L Sleeping Car Conductors, merged with the Railroad Trainmen and the Railway Conductors, respectively. End of footnote. In addition, 5 unions, all AF of L affiliates, the Flint Glass Workers, the Brotherhood of Electrical Workers. Footnote. In recent years, some locals of the electrical workers in the electric light and power and the electrical machinery industries have begun to accept Negroes. But in building construction, shipyards, and railroad shops, where the bulk of the union's membership is employed, exclusion continues to prevail. End of footnote. In addition, 5 unions, all AF of L affiliates, the Flint Glass Workers, the Brotherhood of Electrical Workers, the Plumbers and Steam Fitters, the Asbestos Workers, Heat and Frost Insulators, and the Granite Cutters, usually deny admittance to Negroes by tacit consent. 9 others, the Boilermakers, Iron Shipbuilders, Welders, and Helpers. Footnote. Before 1938, the Boilermakers excluded Negroes, and the quote-unquote white clause is still retained in the ritual. The 1937 convention amended the union's rules to permit the chartering of Negro auxiliary locals. The auxiliaries are limited to localities where a white local exists and where there are sufficient Negroes employed to maintain a local. Negroes have no voice in national union affairs, but must obey all union laws. They cannot transfer except to other auxiliary locals. They are dependent upon the business agent of the supervising white local for job assignments. And although they pay the same dues as white members, they receive only half as much in death and disability benefits, and are not eligible for voluntary insurance plans to which white members may subscribe. End of footnote. The railway and steamship clerks, freight handlers, express and station employees. Footnote. Before 1939, the Brotherhood of Railway Clerks excluded Negroes, and the white clause is still retained in the Union Constitution. The 1939 convention empowered the Executive Council to establish a Negro auxiliary. Auxiliary members must abide by all the rules of the Brotherhood and pay the same dues as the white members, but they have no voice of representation in the governing bodies of the Brotherhood. And the footnote. The maintenance of way employees, the blacksmiths. Footnote. On railroads where the employment of colored persons has become a permanent institution, they shall be admitted to membership in separate lodges. Where these separate lodges of Negroes are organized, they shall be under the jurisdiction of and represented by the delegate of the nearest white local in any meeting of the Joint Protective Board Federation or Convention where delegates may be seated. Rights of membership of the colored maintenance of way employees shall be under the direct control of the System Division. They shall be entitled to all the benefits and protection guaranteed by the Constitution to its members, and shall be represented in the Grand Lodge by delegates of their own choice, selected from any white lodge on the System Division, where employed. Nothing in this section operates to prevent the colored employees from maintaining a separate lodge for social purposes and to receive official communications and information from the Grand Lodge and the System Division. And a footnote. Drop forgers and helpers, the sheet metal workers, the Federation of Rural Letter Carriers, the Rural Letter Carriers Association, and the American Federation of Railroad Workers. The Constitution of this union bars Negroes, but they are admitted to an auxiliary with no voting rights. Permit Negroes to join and give them the privilege of paying dues, but limit their participation to segregated Jim Crow auxiliary bodies which in one way or another prohibit them from having a voice in the affairs of the Union, from negotiating their own agreements, or from having an opportunity to advance in the occupational hierarchy. All but the last two of these organizations are likewise AF of L affiliates. To summarize the above in tabular form: 1. Union which excludes Negroes by provision and ritual. Machinists International Association of Labor, AF of L. 2. Unions which exclude Negroes by provision and Constitution. AF of L affiliates: Airline Pilots Association, Commercial Telegraphers Union, Masters, Mates and Pilots, National Organization, Railroad Telegraphers, Order of Railway Mail Association, Switchmen's Union of North America, Wire Weavers Protective Association. B. Unaffiliated organizations: Locomotive Engineers, Brotherhood of Locomotive Firemen and Enginemen, Brotherhood of Railroad Trainmen, Brotherhood of Railroad Yardmasters of America, Railroad Yardmasters of North America, Railway Conductors, Order of Train Dispatchers Association. 3. Unions which habitually exclude Negroes by tacit consent: all AF of L affiliates: Asbestos Workers, Heat and Frost Insulators, Electrical Workers, International Brotherhood of Flint Glass Workers, American Granite Cutters, International Association of Plumbers and Steam Fitters, United Association of Journeymen. 4. Unions which afford Negroes only segregated auxiliary status: AF of L affiliates: Blacksmiths, Drop Forgers and Helpers, Brotherhood of Boilermakers, Iron Shipbuilders, Welders and Helpers, Brotherhood of Maintenance of Way Employees, Brotherhood of Railway Carmen of America, Brotherhood Railway and Steamship Clerks, Freight Handlers, Express and Station Employees, Brotherhood of Rural Letter Carriers, Federation of Sheet Metal Workers, International Association. Unaffiliated organization: Rural Letter Carriers Association, Railroad Workers, American Federation. In most instances, the exclusionist and discriminatory practices of these unions have been in effect for several decades, and there can be no doubt that they represent the desires of the majority of the membership of the unions. Despite the efforts of a number of members in several of these organizations to have the discriminatory provisions erased, they continue to remain in force. Footnote: a notable exception to this statement was the action taken by the hotel and restaurant workers at its 1936 and 1938 conventions. Before 1936, the constitution of this union stipulated that Negroes must be organized either in separate locals or as members at large. Colored workers were, however, given all other rights and privileges, and in actual practice, the National Union permitted locals to accept Negroes on a basis of full equality, if they so desired. The 1936 convention removed these restrictions as a preliminary move to an organizing campaign among railroad dining car workers, and the 1938 convention inserted the following paragraph into the Constitution. Quote, any local law prohibiting the admission of any competent person, male or female, because of race, religion, or color, is null and void. On the other hand, in recent years, attempts to remove the restrictive clauses from the rituals or constitution of the machinists, the boilermakers, and shipbuilders, the railway carmen, and the railway clerks have failed. End of footnote. Nor does it seem necessary to discuss at great length the underlying motives which bring them into being. Undoubtedly, racial prejudice plays a part, particularly on the railroads, where a majority of the exclusionist unions are found. Most of the railroad unions came into being as fraternal and beneficial societies. To admit Negroes to their ranks on an equal footing would be, in the minds of many white members, tantamount to admitting that the colored man is a social equal, and this the majority of white railroad workers have always refused to countenance. But it is much more important to note that nearly all the unions practicing discrimination, and railway labor organizations are certainly no exception, are organizations of skilled craft workers. In view of the well-known work scarcity consciousness of most craft unionists, it seems more likely that economic self-interest, or, as Spiro and Harris so well put it, quote, the desire to restrict competition so as to safeguard job monopoly, end quote, is the major contributing factor. To exclude Negroes, these craft unionists have discovered, is a convenient and effective method of limiting the number of sellers of a particular type of labor or skill, and that in turn enables the white craftsmen to obtain a larger share of the available work for themselves and or to command a higher wage. A few other craft unions which do not exclude Negroes or confine them to inferior status do nonetheless tolerate, if not sanction, discrimination by their local bodies. Thus, the carpenters and joiners and the painters, decorators, and paper hangers, neither of which has any rules or stipulations providing for exclusion or segregation of colored artisans, follow a policy of organizing Negro workers into separate local unions. While it is true that these separate local unions have equal status with the white locals, and while it is also true that in certain instances, notably among longshoremen, Negroes seem to prefer a separate setup, it is an undeniable fact that in the building trades, as in most other industries, the Negro workers segregated into separate local bodies are at a distinct disadvantage, unless, as is seldom the case, the white and Negro locals cooperate in the allocation of union jobs. The members of the two local groups will be competing for work. since the white local is usually the larger and more powerful, and since its business agent, because of his race, is able, especially in the South where segregation is most common, to contact employers much more easily than his Negro rival, the result is usually that the colored unionists are unable to obtain a proportionate share of the employment. Moreover, discrimination resulting from separate local unions, as featured by the carpenters and the painters, is, although very effective in eliminating Negro workers from job opportunities, quite difficult to prove. Once a national trade union adopts a policy of segregation, the way is open to white locals to deal with the situation as they wish. However much the national officers may deplore the results. In some industries, notably textile manufacturing, the printing trades, and clerical and white-collar pursuits, Negroes are largely excluded from employment by the decisions of management. Undoubtedly, however, such decisions meet with the approval, if not the assistance, of the majority of the white unionists in these fields. On the other hand, in some of the rare instances when Negroes have obtained employment in these industries, they have been admitted to the unions. There are also, it should be pointed out, craft unions which have on a number of occasions endeavored to enforce economic equality upon their locals and which officially condemn discrimination in all of its forms. Foremost among these organizations are the bricklayers, masons, and plasterers, and the operative plasterers and cement finishers. Both these unions have constitutional stipulations providing for $100 fines to be assessed against members who discriminate against fellow members because of race, creed, or nationality, and both give the national officers discretionary power to grant a local charter to a body of craftsmen if the objection of the subordinate union to the establishment of a second local is based on race or national origin. It is worthy of note that in the South, about 50% of the tradesmen over which these two organizations have jurisdiction are Negroes. Had the bricklayers and masons and the plasterers and cement finishers not offered an equalitarian program to Negroes, they would have had considerably more difficulty in organizing the workers in their crafts in the South. Besides these quote-unquote liberal craft unions, those organizations having jurisdiction over workers engaged primarily in unskilled or semi-skilled labor, e.g., the hod carriers, building and common laborers, and the International Longshoremen's Association, and the unions organized mainly on an industrial basis. Footnote: the leading exception to this rule is the exclusionist American Federation of Railroad Workers, which claims jurisdiction over all workers in the industry. However, it was organized in 1901 as a union of shop craftsmen and did not claim its larger jurisdiction until 10 years later. Eugene Debs' short-lived American Railway Union was another industrial union which excluded Negroes. Footnote: apparent exceptions to this rule are the maintenance of way employees and the railway clerks, freight handlers, etc., but the former was organized by an all-white group, the track foremen, who at first entirely excluded Negroes. Later, when they extended their jurisdiction to cover all track workers, they had to organize Negroes who predominated on the southern roads. But in order to prevent them from controlling the unions in the South, they segregated them into auxiliaries. Similarly, the latter union was organized by an almost all-white group and did not extend its jurisdiction over sections of the industry employing many Negroes until some time later. End of footnotes. e.g., the ladies' garment workers and the hat, cap, and millinery workers, all of which are AF of L affiliates, and the unions which are members of the CIO, by and large, afford colored workers equal treatment, both on the job and in the union. The fact that some trade unions use the color bar to restrict competition for jobs should not be regarded as too extraordinary. A great many barriers against economic opportunity are sought by a wide variety of organized groups: farmers, business and professional men, and consumers, as well as by labor organizations, and this is only one of several. That is not to say that the writer condones any of these attempts to create barriers. Each must be considered on its merits, and the use of a color bar by workers' organizations to limit the job opportunities of a minority race is one of the most difficult of all to justify. But whatever one may think of the ethics of trade union discrimination, there is a fundamental inconsistency between the racial policies of most of the organizations in question and the oft repeated principles of their parent body, the AF of L, which never tires of reiterating, re-endorsing, and reaffirming the fact that the AF of L has no color bar, or of proclaiming that the workers must organize and unite under its banner without regard to race, color, creed, or national origin. Section 2. For the first few years after its formation, the leaders of the AF of L apparently made a real effort to adhere to their expressed policies of racial equality. Candidates for affiliation were forced to pledge never to discriminate against a fellow worker on account of color, creed, or nationality, and the 1890 convention refused to sanction the admittance of a machinist union because the organization excluded Negroes from membership by constitutional provision. These sentiments, however, were of short duration. The Knights of Labor, with its ideal of solidarity irrespective of race, was rapidly disappearing as a rival of the AF of L, and the Federation heads soon came to realize that their ideals were standing in the way of expansion. Hence, when in 1895 this same machinist union removed its color bar from its constitution and transferred it to its ritual, it was allowed to affiliate and become the International Association of Machinists. So the AF of L's policy of racial equalitarianism came to an abrupt end. 1 year after the machinists affiliated, the Boilermakers and iron shipbuilders were welcomed, despite a similar method of excluding Negroes. Since then, AF of L officials have not troubled to insist on this questionable rules, but have admitted as affiliates organizations which exclude Negroes by constitutional provision. After 1900, the Federation adopted the explicit policy of organizing Negroes into separate locals, or directly affiliated quote-unquote federal unions, when they were refused admission to an affiliated national union because of their color. The AF of L Constitution was further amended to permit the Executive Council to charter separate city central labor unions, quote, if the situation warranted, end quote, meaning if a local central body refused to seat colored delegates. This method of compromise has proved quite unsatisfactory to Negro workers. The AF of L Executive Council is supposed to act as the quote international end quote for federal locals, but as a matter of fact, it is rarely in a position to do so. Usually it refers matters pertaining to these locals to the national union which has jurisdiction in the field. But since the national union to which the affairs of the federal locals are referred excludes Negroes, it is not surprising that colored workers organized in federal locals have lacked competent assistance in settling grievances and in negotiating contracts, and have failed to receive adequate support in preventing the encroachment of white workers on their job opportunities. Moreover, when, as in the cases of the railway clerks and the railway carmen, the exclusionist unions have amended their rules so as to permit the affiliation of Negroes in a subordinate, Jim Crow status, the AFL Executive Council has not hesitated to revoke the federal charters, despite the opposition of the affected colored workers, and to transfer the locals to national unions under rules which deny Negroes even the autonomy which they enjoy under federal local charters. The Negro migration into northern industry during World War I brought the color question to the fore in several AFL conventions. Most important for our purposes was the discussion at the 1920 meeting. Federal locals of railway coach cleaners introduced a resolution demanding that the railway carmen, which had jurisdiction over that group of workers, either remove its color bar or permit the coach cleaners to establish a national union of their own. The same resolution demanded that the AFL take action on the refusal of the machinists, the boilermakers, and iron shipbuilders, and the blacksmiths and drop forgers to admit Negroes. A resolution similar in content to the one introduced by the coach cleaners was offered by federal locals of Negro freight handlers, who demanded that the AFL take action on the refusal of the railway clerks to admit Negroes. Reporting on the resolution of the coach cleaners, the Resolutions Committee found that the machinists and the boilermakers had, quote, no law in their constitution prohibiting the admission of colored workers following the trade, end quote, and that the blacksmiths issue charters to colored workers of the trade and have no law denying admission to colored workers. The committee did find that the railway carmen excluded Negroes. Therefore, it could only, quote unquote, recommend that the carmen eliminate from their constitution all reference to the admission of colored workers. The resolution of the freight handlers was referred to the Committee on Organization. It non-concurred on the ground that the AFL could not interfere with the autonomy of an affiliate, but after one of the most vigorous debates on the race question in the history of the Federation, an amendment was carried recommending that the railway clerks remove the color bar. The report of the Resolutions Committee on the resolution of the coach cleaners contained a significant number of factual omissions. It is true that neither the machinists nor the boilermakers have clauses denying Negroes admission in their constitutions, but both at that time excluded Negroes by provisions to that effect in their rituals. It is inconceivable that the members of the Resolutions Committee did not know this. It is also true that the blacksmiths issued charters to Negroes, but a glance at footnote 11 will show the purpose of these charters is to control the competition of Negroes, to prevent them from advancing in the occupational hierarchy, and to deny them a voice in the affairs of the Union. The action taken by the conventions of the railway carmen and the railway clerks on the 1920 AFL convention's recommendation that they remove the color bars from their constitutions is also revealing. Meeting in 1921, the railway carmen amended their constitution so as to permit the chartering of Negro auxiliary locals with rules not unlike those imposed on colored workers by the blacksmiths. This the AF of L Executive Council found quite satisfactory. It revoked the charters of the Federal Locals of Negro Coach Cleaners and turned them over to the Carmen's Union. Thus, Negro coach cleaners lost the right to run their own unions and to attend AF of L conventions without being granted anything worthy of mention in return. The Railway Clerks Convention of 1922 did not even go as far as the Carmen's Conclave of the previous year. When a resolution urging the elimination of the quote-unquote white-only clause was introduced, it created such an uproar that it was declared out of order. No action was taken on the question. But the AF of L exacted no penalty on the clerks' union for ignoring its recommendation. Having once admitted as autonomous affiliates organizations excluding Negroes, the AF of L was powerless to force equalitarianism upon a recalcitrant international except by expelling it from the Federation, and this has never been done. As membership in AF of L unions declined in the 20s, interest in organizing Negroes also died down. The Federation did not trouble to give serious heed to proposals of Negro leaders or other socially minded individuals interested in achieving a greater organization of colored workers. It was not until the resurgence of trade unionism during the decade of the 30s was coupled with the presence of a recognized spokesman for Negro labor at AF of L conventions in the persons of A. Philip Randolph, president of the Brotherhood of Sleeping Car Porters, that the debate on the minority race question again became a feature of AF of L conventions. Yet the results continue to be disappointing. At the 1934 convention, for example, Mr. Randolph demanded expulsion from the AF of L for quote-unquote any union maintaining the color bar. The Resolutions Committee voted adversely on the grounds that quote the American Federation of Labor cannot interfere with the autonomy of national and international unions, end quote. However, an amendment to this report was adopted which authorized the appointment of a 5-man committee quote to investigate the conditions of the colored workers of this country and report to the next convention. The committee, composed of John E. Rooney of the Operative Plasterers and Cement Finishers, John Brophy of the United Mine Workers, John Garvey of the Hod Carriers and Common Laborers, Jerry L. Hanks of the Journeyman Barbers, and T.C. Carroll of the Maintenance of Way Employees, held open hearings in Washington and recommended a threefold plan. 1. That all international unions which in any way bar Negroes or afford them only inferior status take up quote, Negro question at their next convention for the purpose of harmonizing Constitution rules and practices to conform with the oft-repeated declaration of AF of L conventions on equality of treatment of all races within the trade union movement. 2. That the AF of L issue no more charters to unions practicing discrimination. And 3. That the AF of L inaugurate a campaign of education quote, to get the white worker to see more completely the weakness of division and the necessity of unity between white and workers to the end that all workers may be organized. Although this report would by no means have solved the AF of L's race problem, it might have provided a workable method whereby significant reform could have been accomplished had not the Executive Council effectively sabotaged the whole thing. Instead of allowing this committee to report its findings to the 1935 convention, as it had been directed by the resolution which created it. William Green, president of the AFL, handed over the report to George M. Harrison, an AFL vice president and president of the exclusionist railway clerks. In so doing, Mr. Green followed a very unusual and, without doubt, unconstitutional procedure. The committee had been ordered by a convention, the AFL's highest governing body, to report directly to it the following year. Yet, Mr. Green permitted a member of the executive council to substitute a document more pleasing to himself. In fact, one wonders whether any report would have been presented to the delegates had it not been for the continual prodding of A. Philip Randolph. As it was, Mr. Harrison delayed action until about 10 p.m. on the 11th and last day of the convention. By then, the delegates had already become exhausted and divided by the craft industrial union controversy. And so, when President Green submitted a totally innocuous document, which Mr. Harrison had substituted for the original committee report, advocating no action except education, it was adopted by the tired delegates over Mr. Randolph's protests. Despite the fact that the suspension of the CIO union by the AFL Executive Council provided Randolph and his supporters with an excellent argument with which to demand the expulsion of unions violating the AFL Constitution by excluding workers because of race, they had been unable to convince that body that it is guilty of any inconsistency. Moreover, the departure of the more liberal industrial unions into the CIO renders it very unlikely that either the AFL or its constituent unions will take any action on their own initiative to remove color bars. On the other hand, however, is the fact that increased publicity has been given both union affairs and the rights of minority peoples by the war, and this has supplied new ammunition to those who are demanding the end of union exclusion. Bolstered by the appointment of the President's Committee on Fair Employment Practices, a development for which he was in no small way responsible, Mr. Randolph introduced two resolutions at the 1941 AFL Convention. The first called for the appointment of a 7-man committee to investigate discrimination by affiliated unions and to report back to the next convention. When the resolutions committee reported adversely, Randolph rose to cite case after case in which AFL unions were preventing Negro workers from obtaining employment on defense projects. The Boilermakers and shipbuilders and the machinists drew his heaviest fire for preventing the employment of Negroes in shipyards and airplane plants. But the building trades, the carpenters, the painters, and even the bricklayers and the plasterers and cement finishers were also prominent on his list. Some of the presidents of the unions mentioned in his report attempted to answer his charges, but none of them was able to refute his facts. The official AFL attitude was clearly stated once more in the speeches of 3 Federation spokesmen: John P. Frey, president of the Metal Trades Department, Matthew Wohl, a vice president, and President William Green. In brief, they stated: 1. That discrimination existed before the AFL was born, and that human nature cannot be altered. 2. That such a committee, as proposed by Randolph, violate the sacred doctrine of autonomy of federation's affiliates. 3. That the AFL per se does not discriminate, because it gladly accepts Negro workers into its directly affiliated federal locals. Besides, the AFL hopes that, quote, if there is any barrier in the way of organizing Negroes, it will ultimately be broken down. And 4. That the Negroes should be grateful for what the AFL has done for them. To which Mr. Randolph and his supporters replied: 1. That condoning existing discrimination, the AFL had nurtured its growth. 2. That Randolph's proposal would not violate trade union autonomy, but would only investigate a means of ending discrimination. Mr. Wolves claimed that it would do otherwise was merely an appeal to the delegates to vote against the proposal by misstating intents and purposes of the resolution. And 3. That not only does the policy of organizing Negroes into federal locals give tacit approval of discrimination, but the AFL only recently had itself committed an act of discrimination against Negro freight handlers and stationers who had been so organized. The exclusionist Brotherhood of Railway Clerks had amended its rules so as to permit the organization of Negroes in segregated Jim Crow auxiliaries, the members of which are not allowed to negotiate with their employers or to have a voice in the affairs of the Brotherhood. Over the protest of the leaders of these Negro workers, the AFL Executive Council revoked the federal local charters of these workers and allowed the railway clerks to assume jurisdiction of them. Inaction on the part of the Executive Council, which duplicated the one 20 years earlier in the case of the Negro coach cleaners and the railway carmen. The last point, 4, brought out by Mr. Randolph and his supporters was that Negro workers are grateful for what the AFL has accomplished, but they feel that it could and should do far more. Defeated in this attempt to force at least a study of AFL discrimination, Randolph attempted to have the AFL convention go on record as opposed to Jim Crow auxiliaries, but P. Frey declared that if the resolution was passed, it would forbid unions to establish ladies' auxiliaries composed of the wives and daughters of union men. On the basis of this pretext, the resolution was defeated. Similar resolutions introduced by Randolph at the 1942 convention met a like fate. The tenor of the debates at both the 1941 and the 1942 conventions offers little hope to Negroes that the offending unions will relax their discriminatory rules and practices. Fortunately, the racial policies of the TheCIO and its affiliates, to an examination of which we now turn, are in general much more liberal. Section 3. One of the main objectives of the TheCIO, according to its constitution, is to, quote, bring about the effective organization of the working men and women of America, regardless of race, color, creed, or nationality, end quote. Thus far, there can be little doubt that both the TheCIO and its constituent unions have sedulously adhered to this non-discrimination policy in organizing Negroes. Of course, this is not to say that colored workers have never been accorded unfair treatment by either TheCIO members or local unions, but insofar as this writer is concerned, no national TheCIO union excludes Negro workers from membership or segregates its colored members into separate local unions. Moreover, the national officers of the TheCIO unions have, by and large, a consistent record of practicing what they preach in regards to the treatment of Negroes. It is not especially difficult to comprehend why the TheCIO has pursued its liberal racial policy. Unlike craft unions, which are organized on an exclusive and narrow basis and which depend upon their control of a few highly skilled and strategically situated jobs for their bargaining power, industrial unions acquire their strength by opening their ranks to all the workers in an industry. The United Mine Workers, the Amalgamated Clothing Workers, and the Ladies' Garment Workers have been organized on an industrial basis for many years prior to 1935, the year their leaders founded the TheCIO. Few, if any, labor unions had better records for fair treatments of Negroes than did these three. Besides, their officers foresaw that the projected campaigns to organize the workers of the iron and steel, the automobile, and the other mass production industries would be doomed to failure unless the unions in these fields opened their doors to workers of all creeds and colors. Finally, the CIO contains within its ranks most of the left-wing elements of the American labor movement. These groups have always most vociferously opposed all forms of racial discrimination. For these reasons, then, the CIO has attempted to enroll workers regardless of race, creed, color, or nationality. True economic equality, however, involves more than organizing workers into one union regardless of race. It entails also the establishment of some standard by which jobs may be allocated without prejudice. The general principle adhered to by most unions in this respect is that seniority of tenure, with certain qualifications for ability, should be the governing criterion. But it makes little difference for the purposes of this discussion what the standard is as long as it is applied without discrimination. The question is whether this standard has been applied fairly, A, with respect to layoffs and rehirings, and B, with respect to promotions. The application of racial equality to seniority in layoffs and rehirings has not caused very serious difficulties. The fairness of such action is too obvious for either management or white workers to protest, and the principle now has fairly general acceptance in a large segment of American industry. On the other hand, however, the question of literal application of the equalitarian policy to seniority and promotions has caused serious difficulties. Because few Negroes have been promoted to the better paying jobs in the past, white workers have come to regard white priority as the established order of things. At the same time, the Negro workers have justly pointed out that if the principle of equal treatment is to have real meaning, it must be applied to this as well as to other aspects of the collective bargaining agreement. The manner in which this issue has been resolved has varied considerably from place to place and from region to region, but it may be said that the national officers of such unions as the steel workers, the automobile workers, the aluminum workers, and the marine and shipbuilding workers have made praiseworthy attempts to enforce a literal application of promotion seniority regardless of race, and in the North, despite some opposition from their white members and local leaders, they have been able to open up a sizable number of new employment opportunities to Negroes. In the South, however, these same national union leaders have felt it necessary to act more slowly in altering the status quo, for there they have encountered a far more determined opposition from their white membership. Consequently, they have felt that to force the issue would result either in wrecking their southern locals by internal dissension or in inducing predominantly white memberships to transfer allegiance to rival unions, the leaders of which are not committed to a policy of racial equality. To give a few examples, the Marine and Shipbuilding Workers Union has collective agreements with the Federal Shipbuilding Corporation of Kearney, New Jersey, and with the Alabama Dry Dock and Shipbuilding Company of Mobile, Alabama. At the former, the union has opened up the company's apprentice training school and many top bracket jobs to Negroes, who compose approximately 10% of the employees there. At the latter, however, Negroes continue to be barred from advancing beyond semi-skilled levels, a policy inaugurated by the company many years ago and left largely unchanged during the 4 years in which the union has had contractual relations. Should the union officials attempt to alter this long-standing policy, they declare, quote-unquote, disruption would result. What they mean is that the white membership About 85% of the Alabama company's employees would swing over to a rival union, the AFL Metal Trades Department, which in two National Labor Relations Board elections has unsuccessfully attempted to wrest bargaining rights from the CIO union. In both these elections, most of the Negroes supported the marine and shipbuilding workers, the second time, despite its failure to improve their occupational status, but for very good reasons nonetheless. The Metal Trades Department includes the machinists, the boiler makers, and shipbuilders, the electrical workers, and the plumbers. None of these unions usually welcomes Negroes on equal terms. The Metal Trades Department has a contract with a neighboring mobile yard, and there the only Negroes employed out of approximately 10,000 workers are 22 porters. Had the Metal Trades Department won bargaining rights at the Alabama's company yard, the Negroes feared that they would have been entirely displaced, just as were most of the colored employees of the Tampa Shipbuilding Corporation, Tampa, Florida, soon after the Metal Trades Department signed a contract in 1938. Consequently, the Negro workers at the Alabama company gave their support to the union, which had by far the better record for fair dealing with members of their race. The writer's field notes contain many other illustrations, although few are so clear and vivid. The Aluminum Workers Union has a strict seniority rule governing promotions in its contracts with the Aluminum Company of America. In northern plants, Negro workers have derived much benefit from this provision. At the Alcoa, Tennessee plant, however, concessions have been made to the white workers at the expense of the Negroes. In the Pittsburgh iron and steel industry, Negroes have been advanced to skilled production jobs as a result of the contracts of the United Steelworkers. Formerly, it was not unusual for many qualified colored workers to be passed over. In the Birmingham, Alabama area, however, there has been no great change in the racial occupational picture. No two unions have a better record in practicing equality than the automobile workers and the ladies' garment workers, to take a case from the AFL. Yet neither of these organizations has prevented its locals in Atlanta, Georgia, from depriving Negroes of rights guaranteed by their respective union constitutions. It was to be expected that so radical a change in industrial mores as the application of racial equality to promotions would meet with considerable opposition. It is not therefore remarkable either that the principle has been applied imperfectly or that it has been less rigidly adhered to in the South than elsewhere. Nevertheless, in a very short period, significant progress has been accomplished in extending to Negroes the right to advance in their occupational hierarchy in accord with their ability. Whether unionism will one day lead the way to a fairly general acceptance of non-discrimination in promotions, which this writer believes to be an acid test of the workability of equality in the labor movement, only the future can reveal. If, however, this practice is to become widespread, it is imperative at this time that equalitarian-minded and not exclusionist unions win bargaining rights in new and expanding industries. Nowhere is this fact better illustrated than in the manufacture of aircraft, surely one of the great industries of the future. Section 4. Before the current expansion in aircraft production was induced by World War II, the industry was noted for its, quote, almost universal prejudice against Negroes, end quote. This was the result of management decisions, for at that time the workers in the industry were for the most part unorganized. Today, despite acute manpower shortages, The numerical participation of Negroes in aircraft production is woefully small, since only a few companies have tapped the Negro labor reserve to any great extent. Since the beginning of the American rearmament program, a substantial number of workers in the aircraft industry have been organized by the International Association of Machinists and the United Automobile Workers, which have been given exclusive jurisdiction in the industry by the AFL and the CIO, respectively. The reader will recall that Machinist Union excludes Negroes by a provision in its ritual. In localities where the IAM has been recognized as the workers' bargaining agent, e.g., Nashville, Tennessee, or Seattle, Washington, the exclusionist pattern has been strengthened, if not institutionalized. The IAM has also organized the Lockheed Vega plant at Burbank, California, which is one of the few companies employing a large number of Negroes. The local there has even admitted a few Negroes, and this has been hailed as an encouraging sign by the Negro press. So it is. It should not be forgotten, however, that the local union could be forced to dismiss its colored members by the national officers, and indeed should be so ordered according to the IAM's rules. That the national union has taken no action is probably ascribable to its officers' reluctance to invite censure by the President's Committee on Fair Employment Practices. Any statement that the IAM has changed its racial policy is premature at this time, and will be as long as the exclusionist clause remains in the union's ritual. Moreover, the Lockheed Vega case is more than offset by instances of discrimination elsewhere. Consequently, if the IAM should obtain bargaining rights in a majority of the plants in the aircraft industry, it is difficult to see how Negroes can expect anything but strengthened opposition in their attempts to gain employment. And if the IAM is able to obtain closed shop contracts, Negroes may be entirely excluded from a large sector of industry. Footnote: when Negroes demanded the end of exclusion at the Boeing aircraft plant in Seattle, the IAM agent declared this entailed, quote, too great a sacrifice, end quote, writing to the secretary of the Louisville, Kentucky Urban League on April 28, 1941. A vice president of the IAM declared that the IAM opposed any plan to train Negroes as machinists because such a program was, quote, designed for the purpose of creating cheap labor for employees, even though it is disguised as the National Defense Program, end quote. In January 1942, President Roosevelt had to intervene to force a San Francisco local of the IAM to give working permits to competent Negro shipyard labor. And in July 1942, the Committee on Fair Employment Practices forced an IAM local to cease distributing cards urging white workers to join to prevent the use of Negroes in skilled jobs, and another one to cease using the closed shop provision of its contract to bring about the discharge of Negroes. End of footnote. The experience of the colored workers with the United Automobile Workers has been much more pleasant. The UAW actually facilitated the introduction of Negroes in the industry. Prior to the defense program, the UAW had enrolled Negroes on an equalitarian basis, but had made little effort to improve their occupational standing. As a result, 75% of the 30,000 Negroes in the automobile industry, who comprise about 6% of all automobile workers, remained concentrated in the tough, dirty work of the factories. With the outbreak of the war and the conversion of the automobile industry to aircraft production, much of the foundry work disappeared, except at the Ford River Rouge plant, where besides the usual concentration in the foundry, Negroes were also employed in production and assembly line jobs. Little provision was made to retrain and reclassify Negro workers. The national officers of the UAW, however, demanded that Negroes be retrained and upgraded. National and local interracial committees were established to enforce the union's non-discrimination policy. Discrimination in UAW locals has not disappeared, but as a result of the action on the part of the national officers, Negroes who would have been displaced have instead been retrained and upgraded into better paying jobs. When white workers conducted illegal stoppages in protest against the assignment to machines of former Negro janitors who had taken war training courses, R.J. Thomas, UAW president, ordered the strikers to return to work or suffer loss of union membership and employment. The Negroes have remained at their machines, and the ringleaders of the disturbance have been dismissed. If then the UAW should obtain bargaining rights in a majority of the plants in the aircraft industry, Negroes may expect some treatment in their attempts to gain a more equitable share of the industry's jobs. And if the UAW is able to obtain closed shop contracts, the national leaders will be in an even stronger position to enforce their equalitarian principles on recalcitrant local memberships. Section 5. This brief survey of Negro union relations has shown that labor organizations can be a great force either in imposing severe obstacles upon Negro workers or in assisting them to overcome the difficulties which they face in their efforts to obtain greater economic opportunities. It would seem that prior to 1935, unionism was more of a hindrance than a help to Negro workers. Since 1936, however, the pendulum seems to have swung the other way, and thousands of Negro workers have benefited from increased wages, improved working conditions, and job security as a result of collectivism. Moreover, it seems likely that unionism will continue to affect the welfare of Negro workers favorably, with the exception of the machinists and possibly of the boilermakers and shipbuilders, the electrical workers, and the plumbers and steam fitters. Most of the unions which habitually discriminate against Negroes either are relatively small or else are confined to industries in which the trend of employment had been declining, particularly the railroad industry. If our optimism proves correct, trade unions will perform a real service in helping to alleviate the American race problem. Footnote. The reader will recall that the electrical workers and the plumbers have no rules prohibiting the admission of Negroes, but that they generally do not admit them in actual practice. End of footnote. End of Organized Labor and Negro Workers. Cornell University by Herbert R. Northrup, June 1943.